Hello, we're here today with Catherine Ballantyne, who's the head of litigation at Hunt & Hunt Lawyers down here in Melbourne. And we're going to do a few things with this. We're going to start talking you through some of the processes and a bit of the background about litigation and alternative dispute resolution, because everybody seems to love that terminology, don't they, Catherine?
They do. It's a bit of a buzzword at the moment.
Well, buzz 3 words, there's 3 of them in there.
Yes.
All right, well, we're going to start. We're going to kick it off. When I've got a dispute with somebody, so we're in a commercial dispute, how do I choose as a client between the concepts of mediation, arbitration, negotiation, and litigation?
Well, I would say at first instance negotiation, because that's essentially between the parties or the parties' representatives, like lawyers. I'd say at first instance always try negotiation, because if you can settle the matter without going to one of the other three, it's going to be a lot cheaper for you. So that's always the first step.
It's also about outcomes, though, isn't it? Like if you're negotiating an outcome, you're not relying on something else to happen to make it work. I mean, you've got your outcome that you're commercially happy with.
Well, that's right. And you can negotiate things that, say, a court proceeding may not be able to offer. A court proceeding is within a very limited scope of what they can offer and what's pleaded, whereas a negotiation, there can be all sorts of different variations. And so you might be able to get a very good commercial outcome that wouldn't be available in litigation.
So does that make litigation the last of the 4 options? I mean, is that your final step?
Quite possibly. Often what you will do, first of all, you look at the contract between you, if there is a contract between you. If there's a contract, it might have a dispute resolution clause. So it might talk about you go to arbitration or mediation. Arbitration is similar to court proceeding, except it is a faster, more commercial way, and it is done by a private individual, not a judge. So they determine it. They might be an expert in the field, and it relies less on court documents and formal evidence, and is a faster, more streamlined way. So your contract might require arbitration.
I was going to say, I've seen a lot of contracts, especially cross-border ones that have arbitration clauses in, even specifies, you need to do this in the arbitration courts of Singapore, for instance. I mean, that seems to be fairly common these days.
Yeah, that's very common, and it is often cross-border or often in the construction industry where you want a quick, more cost-effective way of resolving disputes. And then there is mediation, which every court proceeding will have a mediation, but often it's worthwhile trying to go to mediation before you even issue proceedings to see if you can settle a matter and save your time, effort, and legal fees. It's an option that many people take up. So with mediation, there's an independent third party, and they're there not to determine the dispute, but to facilitate the mediation and facilitate the negotiations between the parties.
So if we start out, so negotiation is going to rely purely on 2 people either side of a table with their lawyers holding their hands and talking about a solution. And if they can all agree, great, we walk out of there and, everybody's happy. The next step would be the mediation part, where it's effectively saying, there's somebody there to help you, guide you through the process, and different rooms, like you're not sitting at the same table, so you don't have to see the person who's angry with you or you're angry with.
Well, sometimes it depends. I mean, it depends on the party. Sometimes the parties say I cannot possibly be in a room with them. And if that's the case, we keep them completely separate. Mediation has the flexibility. A lot of mediations start off with a joint session where you both put your positions, but then you move off into separate rooms, and the negotiation has the mediator or the lawyers going between. And I always say to people with mediation, the first offer is always going to be insulting, and you're always going to want to walk out. But often by the end of the day, and often mediations will go all day and often into the night, the case that you think couldn't be settled, everyone eventually gets there. It's actually quite common to settle at a mediation even when you think there's no chance. So,
yeah. And so mediation, again, that's an agreed solution. It's not somebody telling you what you have to do. That is we walk out of there and both sides are probably unhappy, but happy at the same time.
Well, that's right. It's an agreed solution. And once again, you can do some creative things that you can't do within the formal court proceeding.
Yep. Now, arbitration's the next step on, or a different step. I think you either got to mediate or arbitrate, aren't you, in a sense? So, but that's got an arbitrator who's going to. Do they actually tell you the answer at the end of it, and that's what you have to do?
Well, that's right. So an arbitration is like an informal court process. So the arbitrator will determine it. They may not be a lawyer. They might be an expert in the field. They may be a lawyer. It just depends who you choose by agreement or who is appointed, and what your clauses contemplate. But basically, you present your evidence to the arbitrator and they make a decision.
Yeah, and the scariest one is litigation, isn't it? When you land yourself in one of our various courts at different levels and you're relying on a judge effectively to do any of those go to juries, or is it all judges for litigation?
For most of our commercial litigation, it goes to judges. Defamation can go to a jury, but more often it is just a judge sitting alone. So it's someone who doesn't know anything about you, doesn't know anything about the other side, and they literally have to determine it off the evidence. And that's what a lot of people forget. They forget that it really comes down to evidence. The court isn't always the fair outcome. It's what can be proven. And that's essential.
Yes, which is always interesting. But yeah, I imagine you see some fairly odd outcomes there that you don't expect either way.
Well, that's right. And especially when you are not relying on documents, many cases rely on documents, but when they're relying on witnesses, of course, standing in the stand in an unfamiliar environment, being cross-examined is not a pleasant experience for anybody. And witnesses can sometimes say unexpected things, make unexpected concessions, or change their story up on the stand. So anything can really happen. And when it's a case sort of he said, she said, that's when it becomes, very risky, very risky. And that's why we always say in most cases, and not all cases, settlement is at least a preferred outcome because it's certain. You've got that certainty.
Cool. Well, awesome. And that's Hunt and Hunt taking you through the ADR selection process, or we might come up with a pretty good name for it, but that's effectively it. That's the steps of litigation.